Hi, my name is Robert Chelle with Chelle Law, and I assist physicians with employment contract and independent contractor agreement issues. Today, I'm going to talk about non-competition clauses for a physician. And so if I am reviewing a contract with a physician, sometimes a large portion of that can be around the non-compete. So I'm going to talk about what's a standard non-compete, what you can negotiate, and then some red flags to look for. Now, first, the most important thing is you need to identify what the laws are in the state that you're going to practice in. I'd say the vast majority of things are completely standardized across the country, meaning your compensation, your benefits, malpractice insurance, almost all of those things translate from state to state. The one major thing that changes via state law is the non-competition clause. Maybe some of the other restrictive covenants, non-solicitation agreement as well. But for the most part, the non-compete is the main thing that changes state to state. So identify if you're in a state where they're enforceable. There are a handful of states that they're completely unenforceable. More and more states over the last 3 to 5 years have begun instituting restrictions or outright bans on non-competes for physicians. Indiana, for instance, a few years ago, instituted a rule that you couldn't have a non-compete for a primary care physician. And then last summer, they instituted another rule that says if you work for a hospital or a large health network that you can't have a non-compete. So, and that's just, kind of one instance of we're creeping towards outright bans in many of the states, but we're not there yet. And certainly nationally, I would be surprised if, considering the current Supreme Court, that we would ever see an outright ban on non-competition clauses. So I think if you're hoping for something like that, it's going to happen at the state level. So first thing to do is identify what the rules are in your state. Second, what are the standard components of a non-compete? Well, there's 3 main things. It's the scope, meaning what can't you do, how long it lasts, the temporal restriction, and then the geographic restriction, in what area can you not practice. So the first thing is scope. This is generally pretty easy for a physician. Normally, whatever you're board certified in, that's what you can't do. Now, if I was a hospitalist, emergency medicine, primary care, I would want it specific to what you're doing for that employer. So for instance, if you're a hospitalist, you don't want to say you can't practice medicine within 10 to 15 miles of the hospital that you're working at. You would just want it to say you can't practice as a hospitalist. And therefore, you have other options. You could work primary care. You could do urgent care. You could be, in an emergency department. So you want flexibility. Now, if you're a cardiologist, you're kind of out of luck. It's just going to say you can't practice as a cardiologist, and then you're just going to have to deal with that for the period of time. So that's the first thing is scope. The next thing would be the temporal restriction, how long it lasts. I would prefer, and I always suggest that we don't accept anything over 1 year long. Sometimes you'll see 2. Generally, you would never see more than 2, but most states would find a 1 year non-compete to be a reasonable and enforceable amount of time. So if you're trying to negotiate your non-compete, getting it down to 1 year is certainly a reasonable ask. The last thing would just be the geographic restriction. There are many nuances to this, and a lot of it is specialty dependent. So a standard non-compete would just be you can't practice, in your specialty for 1 year and 10 miles from your primary practice location. Now, kind of the difficulties of this could be maybe you're with a practice that owns many different facilities in the area, and the non-compete says you can't practice within 10 miles of every facility that we own. And obviously, if they have 10 facilities in a city, that could be an extraordinary burden on the physician trying to find a job. So what you would want to do is limit it to the places where you have provided the majority of your care. So maybe 2 locations at the most, but what you don't want to do is accept a non-compete at places where you haven't even provided care. You also want to limit the amount of time that it can apply to a location. I'll give you an example. Let's say you work for an employer in year 1, they ask you to fill in an office, for a week or so, and then you're there for 5 years and you haven't worked in an office for 5 years. Well, you want the language to say that it only applies to locations that you've worked in the last 12 months, not forever with the employer, because you would hate to have it attached to a location that you haven't worked at in 5 years, and then it just limits your options. As far as how, the geographic restriction, what's fair and what's not, kind of depends upon where you're at. Are you in an urban environment? Are you in a rural location? Sometimes a block or 2 in New York City would make sense, whereas 20 miles in a rural location, could be considered reasonable. So there's many factors that go into a non-compete review, and those are just some of the things that we would generally talk about. If you have any questions about your non-competition clause, employment agreement, independent contractor agreement, feel free to contact my law firm at the information listed below in the description. And I appreciate you watching the video. All right, thanks. Take care.